So, but look long and hard at that one, and we hope you would not allow that same loosening for the PUC and other 3-member boards in the state that have greater power, greater taxing authority, or greater financial responsibilities. Questions on that?
Is that at the risk of, talking PUC, at the risk of hindering their normal day-to-day activities? I mean, geez, you've got 3 commissioners that share an office in the first floor of the state capitol, and if one commissioner walks by the other's office and even goes to the point of stepping in to say good morning.
Technically, that's, you're on. Yeah.
You know, and I hate to get to that point, and I did speak with one of the commissioners earlier this week, and that already has become an issue that they need to put a staff member in the middle of their conversation,
right,
in order to even meet at the coffee pot.
Yeah, it is an issue for 3-member boards.
Could it be defined more specific as 3-member state boards versus 3-member township boards or 3-member county boards? In other words, specific wording in legislation that would separate those.
That's what I hope comes out of the governor's office and the LRC.
Is there anything, any idea about posting agendas in a more public place versus just the door of the office where the meetings might get posted to help?
We don't think that's, we don't believe that's needed.
Okay.
What we are finding is, and what the state law changed last session was that if you post it inside a building, then the building has to be, and it has to be posted a full 72 hours before the meeting, because you only have access to it 8 hours a day for 3 days.
Okay.
But if you post it on a window of the door or of the meeting place where I can walk up on the street and see it, then you can see it for a full 24 hours. So then you can post it Friday night for a Monday meeting and qualify for the 24-hour notice provision. And you could actually conduct business there without the public seeing it if all 5, if a majority of the quorum of the members were there. So it's not one-on-one. That's not what we're after.
Not to get into the weeds on this one, but how do you picture that sort of being regulated or monitored or?
It's done only by exception. It's when something happens,
Okay.
and you find out about it. And typically what happens is one of the 5 will go to the press or will go public, and that's when it's discussed.
Okay, gotcha.
So
You could have a city council meeting or a school board meeting or something where one of the members is absent and they were there in Minneapolis or whatever, and they can be on Skype or something, so they can
Exactly.
take part in the meeting, right?
yes, exactly.
Yeah,
Yeah.
or, and that, or phone, that,
Or, yeah,
and the law allows for that today, I mean, that's there, that
Yeah.
provision is there to do that.
okay.
This should not encumber the use of those kind of techniques and tools for people, for government to act. We're not interested in restricting it. We're interested in observing.
Task force about how you might limit the amount of executive sessions that boards go into, because I know there's specifically defined things that you can go into executive session for, but I served 20 years on a county commission up in Brown County, and I'm telling you, there were a lot of times when we went into executive session, it was just ridiculous.
Right.
No, but there was discussion in the task force about expanding the use of
Right.
executive session.
Didn't you also say his structure of the bill was going to be permissive, not
On the tape recording.
on the tape recording to allow it but not require it?
That would be a hell of a step to make it allowable. Today, they feel they can't.
So what if there's one of the board members in the room who wants to protect their own self? What's the language that says that, what's the penalty if they do choose to record? I mean, obviously anybody, like you say, has a device. Is there if you can loosen things up so much that it almost becomes the standard, then down the road maybe it can be adopted.
We would absolutely support only in-camera review by judges. Absolutely. So if that board member took it out and shared it with me in the press,
Yeah.
that would be a violation of that.
A lot of times, your school boards are talking student issues. you know, and that can get really, really personal.
Oh, very
And that's a real concern from the school board and the administrator's standpoint, you know. So I think looking at the allowing but not requiring would be something that I think that, you know, you could kind of get them on your side, because it was, and any of the executive sessions I was in, I wouldn't have a problem. But again, you get down to those student issues or student parent
Right.
issues, ooh, that,
Should not be public. The judge should be the only person to listen to, other than the board that
right,
is there.
right. And then you'd have, but then you've got parental permission there then too. See, there's a privacy thing there too, that if I'm talking about your student, we're talking about your child in our school board executive session, there's a privacy issue there too. I mean, names are never, we can't even listen, get the name, you know, we can't. So there are things there too that need to be addressed somehow in this.
Oftentimes, student issues that are dealt with behind closed doors by school boards is one of the few things that is actually mandated to be kept confidential.
I can think of a couple of times in the 12 years that I was on the Grand Dual School Board. One time when we were dismissing a superintendent, and another time where a teacher had an improper relationship with a student that, you know, they got a little messy afterwards, and it was debated what was said in executive session and what wasn't. And if we would have had a tape of that executive session, we could have shown right there that everything was on the up and up that happened in executive session. So it could be beneficial at times for the schools.
Or the local radio station is being restricted or actually excluded from being able to cover a local high school game because, for instance, there's a contract in place between the school and some other radio station in the community. So now the other radio station or the newspaper can't come in and live stream that game because there's a contract in place. Or there's restrictions put in place in terms of what you can photograph or can't photograph. Or restrictions put in place in terms of what you can tweet, what the news media can put on social media from the actual game itself.
Still allowed to have a contract, it would be kind of meaningless, wouldn't it? If any other radio station could come in anyway, then why have a contract?
Well, I understand that, but it's exactly right. But and maybe they could structure a contract in such a way that provides some other incentives for that radio station to do some things, you know, that the school wants done. But like again, not to the exclusion of other media. That's the only thing we're asking for. And it may make the contract worthless. It's a wide contract, but so be it.
The contract could say, I suppose, you radio station A will guarantee that you'll come and cover all our games because we want all our
Right.
games covered, something
Right.
like that. You talked about the Activities Association. It made me think, you know, in Clear Lake, we've got the local ITC telephone is partnering with the school, and they broadcast a lot of the games on their local channel 150. But when it came to playoff time, I don't think they were able to do that.
The contract that exists between the High School Activity Association and Public Broadcasting applies to anything postseason, district, regional, and state tournaments. That's where that contract exists. So we've had cases where schools, and I don't know if Watertown has done it, but I know Madison, Data Leader, for instance, has wanted to live stream a regional basketball game when Madison boys were in the tournament last year. Not the state tournament, but the regional game. They went to Public Broadcasting and got permission to live stream that because Public Broadcasting holds the rights to all postseason,
District or regional.
This wouldn't change any of that.
Wouldn't change that. Well, we talked about that
We'd like
because there are concerns there and real concerns, but we just don't feel that whatever we draft here would work.
Senator Begelka, let me give you an example of Pierre, though you mentioned exclusivity. Guess what? When an out-of-town radio station goes to Pierre, they're allowed in to broadcast the game.
But not the local.
Exactly. So it isn't exclusive. It's punitive, it's arbitrary, it's...
So in your example though, Mark, how does this change? Because your state attorney that you're talking about with the pictures was postseason plays only on broadcast, not pictures.
Well,
I mean, is that separated enough?
I couldn't get enough support to go to the next level, but I don't think any time you should be denied access to a public event.
What concerns me here is if schools are doing this now, then what's the next step? To prevent parents from bringing cameras in?